break. My name is Vasil Vasilev, and I'm a representative of APIS Europe, the partner that is responsible for the development of the GDPR in your pocket mobile app. But firstly, I would like to say a few words that I will be entwining the functions of speaker and moderator for this second panel. And I hope that everyone is eager to find out more about the topics that we're going to discuss. Now, allow me to give the floor to Claire Prosson, who she's going to talk about a very interesting topic in the field of GDPR. Everybody is talking about, and specifically artificial intelligence. So without further ado, I give the floor to Claire.
Thank you. Good afternoon, everybody. Thank you for staying with us. There is a double challenge here for me, just talking about artificial intelligence and keeping your attention now after the lunch. So I decided to give you a very good example on how artificial intelligence and data protection has to work together and how you have to find the balance. And I chose facial recognition technology because facial recognition technology is as appealing and fascinating as it is frightening for a lot of people. It's controversial. It raises a lot of questions on societal, ethical, economic, and social realms. So over past decade, facial recognition has emerged as one of the most powerful biometric technologies capable of identifying and comparing verifying individuals based on a digital image or a video frame. So it doesn't work. The slide, sorry. So my intervention will speak about the definition and the issues. I will after talk about how this technology can be a source of progress for human beings, what is actually enforced in terms of the regulations, and what the European Intelligent Artificial Act is proposing for the next decade. For the definition, can I go back? Oh,
the previous one, please.
Sorry, the first one, the previous. I'm sorry, yeah. Because the mouse is a bit tricky for me. Maybe because I'm stressed. Sorry. So the definition: facial recognition technology is used to automatically identify individuals based on his or her face using artificial intelligence and algorithm, such as machine learning technologies. The issues are many. There are technical issues. It means that this technology is still biased. It means the technology makes mistakes. There are two kinds of mistakes, very important for us, is what we call the cognitive bias. This is the one which is provoked by the designer behavior. The designer of the algorithm has this vision of the world, and one is creating the algorithm. It can give you his version of the world, and then can have different results from the same data set depending on how the information is presented. For example, most of the developers, coders, and designers are male. So they can, when they code, when they train the algorithm, they can focus on specific algorithm, and they can discriminate one, even if they don't want to, female, women. You have also statistical bias. It's when the representative sample of the population is not complete. It means that your algorithm is going to train on something which is not complete. So it's biased, it's going to make mistakes. It means, for example, for people of color, they are not in the database. So the algorithm is not going to identify the person in color, and then it can discriminate people in color when the algorithm is working. It happens for the Amazon technology, which was given to the American police. For example, they found that they didn't identify very well colored people, and then there were some discrimination and some wrongful and abuse arrests. So they stop it, and Amazon take off the technology from the police, from the American police. So it's a big challenge here to reduce these mistakes, and we have to train the data, and we have then to find a way to prevent the designer and the databases to reproduce these mistakes, because otherwise we are going to discriminate a lot of people from this technology. There is therefore a big ethical issue on this technology, because it can be used as a very mass surveillance tool. So it means a lot of term of right to privacy, personal data protection, of course, right of children, the elderly, freedom of expression, freedom of assembly and association, the right to good administration, the right to a fair trial, and everything of that. There is a big challenge in terms of democracy. So I would say that authorities at the time regarding this technology is quite reluctant to regulate it, or and prefer to forbid on an absolute basis this technology. I wanted to give you an example of to prove you that this technology is also good for people and for progress. Facial recognition is undoubtedly a technological advancement. In the field of health, for example, facial recognition can be a tool for recognizing genetic disease and psychological conditions. In road safety, facial recognition system detect drowsiness when driving, so it saves lives. Obviously, the police are very much in favor of using any kind of technology in combating crime and terrorism. In dim light or at night, it improves combat situations and soldier safety for the armed forces. And finally, on a more modest note, this technology can save a lot of time in everyday life and be highly convenient in effectively fighting fraud and theft. Many operators use it for securing processes, for opening bank accounts, for example, or for recognizing you on the internet, and like that you prevent fraud on a very secure way. So it's very important to how to regulate this technology, because there are a lot to have in terms of positive progress for us. I wanted to give you an example also where I've been working with at the agenda of the World Economic Forum white paper. We made a white paper on it with Interpol, UNICRI, and the Dutch police. It's Interpol really prays for regulation in order to use it on a secure and a trustworthy basis. They don't want an absolute interdiction, because they can't make their job. It can make their job very difficult. So they really want to find a regulation where they can use this technology in order to stop criminals and prevent terrorism. So I worked with them on the legal experts, and we issued the first paper in October 2021. And in that paper, we set up several principles for law enforcement investigation. For example, as you can read on the slide, we really circumscribe some very important principles like respect for human and fundamental rights, that everything has to be necessary and proportional when we use it, transparency, accountability, there's a system performance, a risk mitigation strategy, and most of them you need a double control, and this control has to be made by human beings and not by machine. So we really work on it, and now we are on the second step of this work, and And we are on the phase of testing because we need to make this technology prove, especially with the mask. When we carry now masks, it's more difficult to identify people, so you can use the eyes. So they really want to work on a very achieved technology in order to get rid of the bias and the mistakes I was talking just earlier. So what we have now in force in terms of regulations, we have the general data protection regulations, GDPR, we are talking about this morning or during this conference. So basically, this technology, as it's collecting sensitive data, biometric data, your face, it's forbidden by the GDPR, except there are some exceptions. And from them, you have the consent, you have the reason of substantial public interest, and you have also, if the system is integrated into the data subject device, which means that the data are only stored in the device. For example, when you use your iPhone to deblock your telephone. The GDPR also compels the provider of this technology to conduct a data protection impact assessment. This takes into account the nature, extent, content, and purposes of the processing and the significant risk it entails for the right and freedom of natural persons. You have also another regulation, which is very important when you use this technology, is the directive which is called Police and Criminal Justice Directive. And like that, in the same way, biometric data and then this technology is really permitted only when it's strictly necessary and when it's authorized by the law of the member states, or to protect the vital interest of the data subject of another natural person, or where such processing relates to data which are manifestly made public by the data subject. So, for example, in France, we can use this technology for the paragraph. When you go to the airport to cross the border, you use your biometric passport, and then the technology is just looking at your face and just comparing it to your passport. It's very easy. It's just avoiding queue at the airport, and it's very safe. And the technology is quite well proven, and there's no big mistakes on it. So the European Data Protection Board has just published new guidelines in May on the use of facial recognition technology in law enforcement. You can still comment it in this report until the 27th of June. The board recalled the importance of a strict framework for the use of this tool, which must, for this board, must remain limited to the application of the Police and Criminal Justice Directive, and give some example of prohibitions for using this technology, especially in order not to recognize people's emotion. We are talking about that this morning. When you're recruiting people, you don't look at don't film the emotion, for example. So please read this guidelines if you want to more understand what is going on this technology. For myself, I think it's too narrow, but I think there's so much more than going just on the police and aspects of this technology, and that we can improve our lives with this technology for other stuff than just preventing crime and offenses or terrorism. In France, the CNIL, which is our French Data Protection Authority, has recently asked to a company, which is Clearview, to stop using facial recognition technology. Last December, the CNIL issued a formal notice to Clearview to stop reusing photographs and videos which are available on the internet. Actually, it was 10 billion of faces. They were scroll up all the internet with all videos and photos throughout the world, and they were offering this service to law enforcement agencies in order to identify offenders or victims of crimes. They were used to query the search engine and find a person based on their photograph. So the CNIL revealed 2 breaches of the GDPR. There was no at all, it was an unlawful processing of personal data, because the collection and the using of biometric data was carried out without any legal basis, even consent. The people didn't know that. And there was also a failure we couldn't have the rights of individuals, including requests for access to the data. So during this procedure, it has to be noted that the CNIL cooperated with other European counterparts in order to share the results of the investigation, because Clearview AI had no establishment in Europe. So all authorities were competent to know about the matter. The CNIL had just summoned this company to stop everything and to erase the data. And this company has 2 months to do it, to comply with it. Otherwise, the CNIL will sanction it. I don't know for the other authorities, but I'm saying it's still pending for them. So it's really interesting to know that our authority are really controlling what we are going on this technology, and are really keen on sanctioning companies which are not making it properly. So now, what is the future? The future can be seen in the next European AI Act. This proposal is not enacted yet, still being possible to be amended. And the purpose of this regulation is to improve the functioning of the internal market by laying down a very competent legal framework. There are already four prohibited artificial intelligence practices, and one of them includes facial recognition technology, and still there are some exceptions. And the European Act is really classifying the tools depending on the risk you have on freedoms and liberties. So my conclusion is that it is clear that the European Union wants to regulate the use of facial recognition, and has to do it in order to reduce the impact it may have on the rights and freedoms of individuals. We definitely do not want a large system of social control in countries where the rules of democracy and fundamental freedoms have to be respected and have to prevail. But in the same time, we must define a reasonable legal framework in order to use that kind of technology, because this technology is a source of progress, can constitute a source of progress, and AI has to be used for human being and at the top center of the human being objectives. So I would terminate by saying what Thomas Jefferson said: eternal vigilance is the price of liberty. So let's do that like that. I mean, thank you.
Claire, for the interesting presentation. Now, to summarize for our audience, during the event, we talked about the GDPR so far. We talked about the current SMEs challenges, and now we entered the future challenges, as the previous presentation has already shown us that AI is something of the future, but rather it's very close future, because it's already happening in reality, and we need to face those challenges immediately. First of all, I would like to thank the participant in today's event and the interest shown, which is, in my opinion, largely a reflection of the need for clearer and more practical events such as this one in the field of GDPR. And in that light, the mobile application GDPR in your pocket, which I am about to present right now, has been developed actually to contribute with clarity and accessibility to the complex rules of the new legislation concerning the protection of personal data. I will have to switch to the mobile application, so just give me a minute. Just end the presentation, please. Unfortunately,
They want to stay on the picture.
I don't know if the mouse is working at the moment. Okay, while we have some time to organize things technically, yeah. As you can see from the screen, this is the mobile application, GDPR in your pocket. And I mentioned that the legislation is not is new. I mean, it's not new per se, but it's definitely new to those who encounter it for the first time. So this is something that we should also consider, and this is why GDPR in your pocket was actually made, because while the regulation is from 2018, there are still new companies and organizations that encounter it for the first time, and this is why there must be a tool that they can find information with ease. So what is GDPR in your pocket? I will start by showing the SMEDATA Project official websites, where you can find the information so far gathered over there. You can find the presentations from today's event also. And you can find where and how to download the application. First off, I will start by saying that this tool was developed as a mobile application originally, but the desktop version was added during the project and its implementation. The reason for that is not only the extension of the scope itself, but rather it's also an indicator that the use of such instruments can be implemented in a more professional environment. This is why the desktop version, I'm delighted to say, as a data protection practitioner, that I use it regularly and it serves the purpose. I mean, it is application to serve its user. It's not just an application that is something attached to the project itself. One of the main goals where you can find on the website was of the project was to raise awareness among citizens and SMEs, but I can also say and point out that it can be viewed also as a learning tool as well. So I'll get back to the application. This is the desktop version. You can download all the versions regardless whether they are for the App Store. You can download it from the App Store as a mobile application or from the iOS store. And for the desktop version, you can download it from the MS Store. They are free to download. We have over 10,000 downloads so far, and the reviews have been great. So I hope that they still keep that way. The GDPR in your pocket, this is the main menu. It is divided into two segments: for beginners or through the eyes of data subjects, and for advanced or through the eyes of data controllers or processors. During the project, we gradually increased the languages used by the application, and at that moment, they are English, German, French, and Bulgarian. The home screen, what you see in front of you, is quite simple and intuitive to use. On it, you see the legal library, where you have synthesized, the legal library concerning GDPR. You have a GDPR dictionary where you have all sorts of definitions and terminology to provide information in a quick and easy manner. And you have guide for citizens and guide for SMEs. They are a topic which I will discuss later in detail. So, speaking of a software solution such as GDPR in your pocket, we cannot forget functionalities. So let's talk a little bit more about functionalities. On the top left corner, next to the menu, you have the options where you can see all the settings and the inside of the application. As you can see, the program menu is just as easy and accessible to serve the user without much explanation. But here the important elements with added value for the users, which I'm about to point out, are useful links, bookmarks, and saved documents. With useful links, you can find with one click away the most commonly searched by relevant sources of information. For example, as you can see, there are links to the European Commission, the European Data Protection Board, and so on and so forth. I mean, these are the most useful links that you will have to access as a data professional during your practice. So they are put in one place so that they can be easily used. Bookmarks and saved documents. Well, let's start with bookmarks. Bookmarks make personal data application, well, even more personal. Why? Because they allow the user to mark relevant information throughout the legal library and have specific documents, which makes the user experience personalized. So, for example, right here, because the download is new, I don't have any bookmarks, but if I go to specific document, it doesn't really matter which one, I can bookmark a specific part of it, so that in the future, if I want to access those or my bookmarks, I will find them easily on this tab. One of the strongest advantages of this application is the fact that all the information is linked through a single search engine. Because I'm restricted at the moment to type in, I will just show you the search engine and explain it to you. The specific thing about the search engine is that it's full text search boosted with sensitive and specific search, meaning that we can either search for a specific phrase or derivatives of a phrase. You can also search globally, which means from the top right corner, you can search in all documents, or you can search in a specific document if you open it for the result you want to find out, which makes it perfect to navigate complex information. So now I will tell you a bit more about the legal library. In it, you can find the EU legal framework, as shown, and you can find national acts by choosing a specific country. I mentioned before that we extended the languages in the application, and this relates not only to the menu, but also to the content. So we have national acts from these countries, and for example, if we choose a specific country, not only do we have access to the legislation, but also we have access to case law regarding, by choosing the specific court. But these are case law practices specifically in the GDPR area, specifically applicable for SMEs. We also have guidelines, opinions, and other instructions from regulatory authorities. All this makes the mobile application a complex database that is complete and comprehensive enough, in my opinion, to serve any privacy professional, because not only do we have the specific legislation in our country, but we can also search for other information in other countries as well. One more thing about the legal library. Once you open a document, it doesn't really matter if it's about the European Union, the International Act, or the national acts. Let's say I will open the GDPR. Once we open it, we see that the text of the document, it's pre-processed and segmented in such a way that it's easier for navigation through its content. And this is where, as I showed you previously, the bookmarks take place. You can bookmark a specific section or a specific article, and this way you can personalize your documents of choice. And now we come to the essential part of the application, the separation between citizens and organizations. Both are similar in structure and content, but as I have already mentioned, they differ radically in meaning and purpose. In both parts, Guide for Citizens and Guide for SMEs, you have a segment called GDPR Made Simple, where you can find out how personal data is protected, the rights, and so on and so forth. So these are frequently, how to say, topics to which are relevant to the citizens. You have contacts with national data authorities of all EU countries, and you have frequently asked questions, which are both in the guides for citizens and SMEs. The only difference is that in the guide for SMEs, you have a decision supporting tool, which I'm about to show you a moment later. So, while for citizens, these are frequently asked questions and answers in general, for SMEs, these are questions and answers that relate to their activities and obligation regarding compliance, thus making it a strong instrument for both parties, regardless whether it's about the rights of the subjects in particular or about the fulfillment of obligation in relation with Article 52.22 of the GDPR, for example. Another thing to keep in mind as a specific for this app is the decision supporting tool, which I told you about. So what is the decision supporting tool? It aims to serve as automated assistant for SMEs, which provides the ability to answer questions and to give a final answer in support of the information sought. To explain it more clearly, I will give you an example. Usually in the activities of a controller or a processor, there are certain events or mandatory obligation for action. Examples may include whether my organization has an obligation to appoint a DPO, or whether a breach of data security, if any, should be reported. Am I a data controller or a joint controller, and so on and so on. Most of these questions are comprehensively set out in the General Data Protection Regulation, but no unambiguous answer is given, as it is left to the discretion of the controller. This often leads to a non-decision making due to the lack of information, which in turn make the law enforcement ineffective. So with the help of this type of questions, I will show you an option of how does this supporting tool work. Let's say, for example, the first question, does my organization need a DPO? It follows the structure and the set out rules in the GDPR. So it's quite simple, but let's say the answer to the first question is yes, we have a definite answer from the application that we need to appoint a DPO. But there are certain questions, let's say, do you know how to organize the personal data protection training in your organization, which does not define answer to that. Then regardless of, well, not regardless, but depending on our choice of yes and no questions, we will have different answers, multiple answers, which might include an additional information. As I mentioned earlier, this is not just a tool that can be used to raise awareness among citizens and SMEs, but it can also be used as a learning tool. Because as you see, the final answer that is given from the application is not only whether yes and no is applicable, but we see that there is some additional information that might be used to include in our accountability process. So the goal is clear with this type of supporting tool to make GDPR more easier, more transparent, more understandable, because behind it, the point is to defend the interest of data subjects like ourselves and not turn it into something unattainable or relevant only in the last minute. So I encourage everyone to download this application, no matter if it's the desktop version or the mobile version. Personally, as a data protection officer, there were countless of times where I use this application because it's very easy to use. It's free, and I should point out that this is the the tool to use if you want to consider yourself a privacy professional, because it's, so to speak, in a sandbox that everything is up to date. The information is not misleading, it's not misguiding. It's there for each and everyone who wants to participate. Thank you very much. Yeah, definitely. Now we continue with the next topic. Speaking of the future, I'm delighted to give the floor to Kristina Radkova Staneva, Director of Legal Affairs and International Cooperation of the Commission of Personal Data. Kristina, the floor is yours.
Thank you very much. Thank you everyone for the participation and for the interest in this conference. I will be the last one speaking today, and to close the conference and especially the challenges before the small and medium enterprises, my topic is the organization of economic cooperation and development. If you saw the title in the program, it's a bit far-fetched. The future we want, better policies for the next generation and sustainable transition. Actually, this is the title of the last statement of the Council of Ministers, the Ministerial Council of the OECD, which came out just a week ago. And the importance for the small and medium enterprises is that the statement focuses on the sustainable transition, meaning more consistent investment in human resources, focus over the future of the new generation, focus of the personal formation of the populations. And of course, a big part of the statement is focused over the economic issues coming forward because of the war in Ukraine and the trade over regulations and so on. The important thing from the Bulgarian point of view is that at the same meeting, the same day, actually, Bulgaria's roadmap, together with the roadmap of Brazil, Peru, Croatia, and Romania, were adopted by this Council of Ministers of the OECD. So from the Bulgarian point of view, we are starting the process of assessing the OECD. And what is important for the small and medium enterprises in Bulgaria from the point of view of the OECD, this is not just the participation of the state into an organization, which is, of course, some challenge by itself, but it's also the adherence to the legal instruments that Bulgaria have to align with through this whole process. Well, it's important to say that this adoption of the roadmap for Bulgaria was made under the Italian presidency of the OECD, so it was really nice to have our Italian friends involved in this process. But for the, as we said, also for the small and medium enterprises, one of the biggest challenges is to manage to transfer data from the European Union to third countries within complying the GDPR and all the requirements of additional safeguards. As our colleagues already told, it's really hard for a small enterprise to find sufficient legal or even financial resources to make a good impact assessment and to transfer data within all the requirements of the regulations and the statements of the data protection authorities and so on. What will be good for the small and medium enterprises from the point of view of accessing the OECD is that Bulgaria, as all the members already done, will have to assess legal instrument by legal instrument and to adapt its legislation and practice also to the standards of the OECD, meaning that these legal instruments can focus also over different areas of the legal and the economic life. From the point of view that protection, for the moment we have many legal instruments that we have to adopt, but they're focused on different areas of the life, meaning the data transfer says itself, the health data, and so on, so on. So Bulgaria will have to adapt little by little to these legal instruments. And by adapting the legal system to the legal instrument, this means that the legislation is getting closer to those legislations of the members of the OECD, meaning that the charge for the small and medium enterprises to make this impact assessment will be really easier towards the countries that are members to the OECD, because the legal system will be at least basically assessed at the prima facie. So they'll have to do, of course, the impact assessment, but with a guarantee of the minimum standards towards those countries that are members of the OECD. Saying that, I would like to emphasize that the accession to the legal instruments to the OECD and the membership of the someday coming of Bulgaria to the OECD doesn't mean that those legal instruments derogate the GDPR or the other legal requirements into the European Union. The legal instruments and the membership of the OECD doesn't mean that we can automatically transfer freely data toward these countries that are members of the OECD. No, this means that the impact assessment will be easier, will be cheaper, and will be at least more guided at the basic legal point of view than if it was a country that is not member of OECD. The transfer tools are, as already was mentioned today, are set out in the GDPR. The additional safeguards are mandatory. So it's clear that they should be presented, but being part of a club of countries that have the same goals, that are following the same pattern, will more or less make life easier even for small and medium enterprises, including in the cases of data transfers towards third countries. So I think that the last week, it was a really good week for Bulgaria in general, and for, of course, all the small and medium enterprises that are involved in the data protection and that are in their everyday life transferring data. So this was from me. Maybe I should give the floor to...
Yeah. Thank you for the presentation and the future that's upon us. We are looking for it. So we keep it short but nice. So this is the final remarks for this event. A lot of information starting from ethical data management, artificial intelligence, policies for the next generation has been set. I'm sure that and you may agree with me that after 5 years of implementing awareness-raising measures, privacy policies and personal data protection allow us to continue improving our skill, our internal procedures, and eventually the overall privacy protection environment. At this very last moment of our journey, allow me once again to express my gratitude to all of you, our project partners. Without your everyday efforts, SMEDATA initiative would not be so successful. The European Commission, without your support, including co-founding, would not be able to start. But above all, representatives of small and medium enterprises. Without you, there wouldn't not be a SMEDATA project altogether. Every end is the same time a new beginning. So this is not a goodbye, this is a new start. Our entire team is looking forward to our next meeting. Thank you all and see you soon.